法會主席。
The President of the Legislative Council.
法案
Bill, committee stage. The Council is now in committee. We will continue to study the Copyright Amendment Bill 2014. Committee stage will continue the first debate. The first group of amendments by Mr. Kam-lam to amend clauses 8 to amend the clauses of clauses 18, 19, 24, 75, 76, and 78, dealing with the addition of contract override provisions. Mr. Lee Chuk-yan, please continue. The amendment was debated starting from the year of the ram, and is now, and we have now entered the year of the monkey, and we are still debating this. And John Zhang said that human problems can be solved by through human action. How do we deal with the three amendments by the pan-democrats, including this provision restricting contract override? Before this meeting, Mr. Kam-lam called a four-party meeting successfully. But was the problem has the problem been resolved? Since it is a human issue, a human problem, shouldn't John Zhang participate and try to solve the problem at the four-party meeting? Whether it was the pan-democrats or the pro-establishment in respect of resolving the issue, they pointed their fingers towards Greg So. Greg So has a responsibility to solve the present stalemate. Greg So should do something. The conclusion was that everybody was looking at Greg So, but we have not seen Greg So doing anything. If it is a human problem to be solved by human action, then who is to provide the solution? Should John Zhang do it instead of Greg So? The reply by Greg So is very simple. He is not going to do anything. The copyright owners and the netizens can solve the problem if they have the consensus. If there is a consensus, we don't need you at all, Greg So. We can solve the problems on our own. What is the role of the administration? When there is no consensus, when there is division of views, then the administration has to do the coordination and try to mediate. The pan-democrats and the pro-establishment also said that the responsibility rests on Greg So, and the monkey, the year of the monkey, means flexibility. What flexibility will be brought into the bill by Greg So that we can narrow down the differences to such an extent that there can be a CSA or several CSAs passed, thereby solving the problem instead of debating the issue. The more the debate, the clearer the arguments and issues. The pro-establishment said that there could be more debates, but the debates would not change your votes. If the pro-establishment members have independent thinking and make a decision after a debate, then after the debates there is a chance to turn the table. But we all know that if your votes have to be changed, then the administration will at first have to step in and resolve the issue. Now, this is your second time you speak. Please speak on the issue of contract override. I am speaking on the way to solve the problem. I want to persuade the pro-establishment, and that is the freedom of contract. Now, there is freedom to enter into a contract, but the law must have a purpose. What is the purpose of the law, of this law? It is to balance the interests of the copyright owners and the citizens. And one point of balance is this. If the contract can override the provisions in the law, then there is no balance to speak of.
Well, in 2011, there was an independent report in the UK, and they already dwell on this issue. Professional associations of libraries and archives were of the view that if contract right owners could use contract to make the exemptions null and void, then is pointless, and therefore they would like to have a restriction against a contract override. They give us one example, the British Library. The British Library has hundreds, more than 100 contracts with copyright owners. All the contractual terms are different, and that's a big issue for libraries, for the library. Since if there is no restriction against contract override, that means they would have to consider more than 100 contracts. It was rather chaotic because some contracts were more restrictive, some less so. So eventually there was a guideline meant to be used for all libraries, and as a result, the contractual terms would be very restrictive. Because there is no exception against a contract override, the exceptions were very narrow as a result, causing great inconvenience to the public. And so they were of the view that the law could not be so unclear. Without contract override exceptions, then it is tantamount to allowing the copyright owner to rewrite the law. So by means of the contract. So wouldn't it be rather confusing for the users and members of the public? Honestly speaking, many of us do not know what we have signed. We just say we agree, we tick against the box, we agree to the above conditions, and that's already done. The harm is done. You've agreed to the contractual terms. So we do not have any exception against contract override. The law here will be very unclear. When we enact a piece of legislation, shouldn't we ensure that it is clear and certain? It should provide certainty. Do you think that these are two principles? If you agree with me, why don't you accept a prohibition against contract override, so that people cannot rewrite the law by means of their contract, so that people will know whether they are being protected by the law? So our argument is many netizens might be inadvertently caught. And the administration has provided exceptions for parody, satire, caricature, prestige, and secondary creations of the like. So there may be a contractual term prohibiting secondary creations. Now, that means this exception is gone. All right, if these exceptions are gone, then we don't know whether what we do on the internet is legal or not. Reading the law, I would have thought that it was okay to do that. But then you have no prohibition against a contract override. As a result, as a netizen, as a member of the public, what I have done becomes illegal, and the situation is very confusing. And Chairman, I think, would agree with me that any legislature should ensure accuracy, certainty, and clarity. And all these principles are violated because you want to stress the freedom of contract. But if you do not consider the legislative objective of the copyright ordinance, then you're being lopsided. This will result in a very lopsided piece of legislation with no clarity and certainty. And protection for netizens will become zero. And this has also failed to address the controversy in society. So please spare the netizens. Do not allow a contract that can rewrite the copyright law. Thank you. Dr. Kwokaki. Just last week, there was an opportunity for this issue to come to a better resolution. I'm referring to the four-side meeting involving the government. The purpose of the meeting is by means of negotiations and give and takes, the copyright amendment bill can be passed in this council as soon as possible. Unfortunately, we haven't seen any new proposals after the meeting. I'm particularly disappointed with Mr. Greg So. As we all know, after the meeting, the Secretary came out to say that there was no consensus between the copyright owners and netizens, and it would be futile to propose new amendments. And therefore, the discussion is still on whether it should be a fair use, and there is no consensus. And there is the only conclusion of the meeting, and you either take it or leave it. If that's the outcome of the meeting, he has really let down all members of the public who have been following our debate for the past few months, no matter whether they are netizens or not. In fact, it is hard to make a distinction because many people are using the internet day in, day out. And what is most disappointing, the Secretary had the opportunity to try to forge a consensus on the amendments we are proposing involving contract override and the other two exceptions. As we said, it's not necessary for all three amendments to be passed for this stalemate to be broken, so long as the administration shows the sincerity and the political energy to persuade different parties. Now, if you just sit here, leaving it to fate, then you are not really living up to your political appointment. You are politically appointed, and therefore you should be the you should be the intermediary or the person to pull the two sides together who are miles apart. The legislators, the netizens and the copyright owners, and try to forge a consensus among them to settle this matter. And you just said after the meeting that the two sides could not come to a consensus, and you could do nothing about it. So this shows that you are neither competent nor willing to address this issue. You missed the opportunity of resolving this matter through that four-side meeting. And may I take this opportunity to respond to Mr. Kam-lam, who is the chairman of the BC. I appreciate him. I appreciate his attendance as the convener of the meeting. However, what he said, something he said was really unacceptable. He drew an analogy of taking a meal. Now, if you just finish all the rice first and deal with the dishes later, the latter would be too cold. Well, if those were not really wholesome food, but poison, that even if you swallow just one mouthful, you could be killed, and you cannot continue the discussion afterwards. the alliance, and some legislators quite do not like the idea of talk as you eat, because this is not the first time. The administration could go back on its words. Forgive me for digressing a little bit. Just like the XRL, the former secretary told us that there would be no cost overrun and it was not necessary to have co-location arrangement. But then a few years afterwards, all things are changed. She's no longer the secretary. So we could feel when we face the consequences, the secretary may no longer be around, and who will be there to resolve the mess. So the best approach is not to talk or chit-chat as we eat. I reminded Mr. Lee Chuk-yen the same thing, and this is you're speaking for the second time, and I've allowed you to digress for the past 5 minutes. I'm coming back, Chairman. There are views that the contract override provision is very controversial. We have checked the proceedings of the House of Lords in the UK. In fact, the controversy was not as serious as referred to by the administration. In fact, the provision was conducive to improving the clarity of the bill. Ms. Lucy Lavelle said at the House of Lords that contract override provisions were to ensure that the public could follow the exceptions and could just disregard what's in the contractual terms, which might be entirely opposite to what's stated in the law. So we are proposing an all-embracing exception. Copyright owners can define their interests and also powers. Chairman, you may recall that when before we moved to this complex, we used to meet at the now CFA building, and then at the roof of the building there is the statue of a goddess holding a balance, and it's not tilted to any side. That means we have to balance both sides. We have to balance the interests of copyright owners and the community. And if it is the right balance, then we should do it. This contract override provisions offers a balance. No matter how well we think the copyright ordinance can protect copyright users. Now, when netizens use any software or apps or browsers or servers, very often they are allowed to sign an agreement. I believe most people will not look with a magnifying glass what's in the contractual terms. If you are a legal layman and if you are not able to know what's in the contract, you will just click agree when you use the apps. That means you have removed your protection provided by the copyright ordinance. And the copyright owners will say that although it is so stated in the law, as the copyright owner, I have the power and ability to disagree. And the consequences, they can take civil action, legal action, or claim the user. and the consequence can be substantial. Recently in the U.S., there are copyright rogues. These companies will collude with copyright owners.
Say, for example, audio and visual companies or lyric writers, songwriters, and they represent them to take action against unlicensed publication of copyright works. And they will charge, or they will collect royalties or fees on behalf of these owners. However, these companies will just send out claim letters or lawyers' letters indiscriminately, and without trying to find out whether these are actually exempted behavior. Netizens, websites, or journalists who have received these letters, yes, they may complain, but if you don't know much about it, you will be very worried. And if you ask them to seek legal advice, it's very expensive, and they don't know whether they will incur even more costs as a result. Well, the government, if indeed they don't agree with the contract override restrictions, and if there is a fund available to give them assistance, say, for example, to help them find information, legal advice, free or at an affordable price to deal with these cases, unless there is such a fund, there is a possibility that copyright owners or these copyright hooligans will exhaust every means to try to exploit the situation. There is a need for the contract override provisions. We've seen past cases with outrageous terms in the contract. You may recall a while back, there was some laundrette. They use some contract which in effect says that, well, they don't have to be responsible for the clothes that you give to them. It doesn't really matter what state it will end up in, or if it's torn, damaged, they don't have to be held responsible. And if the clothes are available and if you don't go collect them, then they even charge you for storage. So these terms of contract don't protect consumers. And this even leaves a trap door open for netizens or consumers, because you won't go get a magnifying glass to look at the fine prints. You just pay $20 or $30 for the clothes to be cleaned, and when something happens, you're told, well, you give me money, that means you agree to the contract. The Consumer Council criticized the situation, and the government dealt with the unfair contractual agreement, and they've done something, and the situation has been resolved. The problem has been resolved. And this is an act showing that you are responsible to protect the general public. Copyright owners, say for example Cash or the Hong Kong Copyright Alliance or some software companies, they have a lot of resources. You may say that an individual who's a songwriter may not have much resources. However, the organizations that represent them will be strongly supported by abundant resources. There is a team of professionals, lawyers helping them. This is an imbalance. So copyright owners have a team of experts with millions of dollars to make use of the situation and maximize their profit. Without contract override provisions, you can foresee that in the future, netizens or members of the public, in any dispute, especially one involving copyright owners, and they will be the underdog. They don't have the money to engage lawyers. When they receive a letter, what are they supposed to do? They stop the secondary creation. They give up their rights. But that should not happen. As our Financial Secretary said today, that, the use of technology and innovation should be encouraged. So there should be a policy to protect it. I so speak in support of the amendment. Thank you. Mr. Peter Jones. Thank you. I support Mr. Dennis Kwok's contract override restriction provisions, because when you apply for an account on the internet, if you've read the terms, you will know that without contract override restriction provisions, even with the 6 exemptions under the bill endorsed, when netizens use copyright owners in their secondary creations, if they communicate the work, they will not be protected by the amended ordinance. The post may be deleted, the copyright work used may be deleted. Sorry, please. Quorum call, please.
Mr.
Peter Jones, thank you. I was saying that if netizens use copyright works in their secondary creation to disseminate or communicate copyright work without the restriction on contract override provisions, well, the posts may be removed or they may face civil or criminal litigation. So without such restricting provisions, then this bill will exist in name only, because netizens may be caught by the law inadvertently. The government opposed to these amendments by saying that Well, there may the copyrighted work as used in the secondary creation may be under the exemptions, but are they allowed to be posted? That is subject to the contract of use of these platforms, and they should not make all platform operators or administrators to accept these terms, because these online platforms, they are companies. They will take into account market operation without considering the rights of netizens to upload such work. But what if the company does not allow netizens to upload copyright works used in the secondary creations? They will be squeezed out of the market. So there is no need to allow the amendment to introduce contract override restricting provisions. However, businesses don't just consider the market. Sometimes they have to make political decisions in order to make a profit in their business. Most of the contracts don't contain words about political decisions. They're all business decisions. And they also said, they also mentioned about making sure that there is a fair right to use. However, without these restricting provisions, the freedom of creation and expression will be restricted. Say, for example, Facebook, a social media, in their terms, under security, it says that you will not bully, threaten, or harass any other users, and you will not post these contents, say for example, inciting hate, nudity, violence, gore. They would like Facebook users to abide by them. However, when it comes to bullying, threatening, hate, inciting, there is no clear definition. And there's also a report mechanism in Facebook. And you can say that I don't want to see it on Facebook. And it may say this is hate. And this is related to discrimination against a disability, about race, etc. So there is the word hate, inciting. So if you want to know about religious bodies, sexual orientation, disability, and illness, if you want to know about the definition, you may not look to the US, where Facebook came from. And you also have to take into account your local legislation. If you're in Hong Kong, you will take into account Hong Kong's legislation. Say, for example, Bills of Rights Ordinance, discrimination against disability ordinance, and the different sets of discrimination ordinance. But we'll actually netizens look up the law to find out? I think it's very unlikely. So even if Facebook users don't agree to the terms, there is nothing they can do. And if there is any behavior that breach these terms, Facebook can delete their accounts. And on more than one occasion, Facebook, sorry, Mr. Zheng, how is it related to copyright, to contract override in copyright? Well, I'm talking about Facebook as a platform and its terms of contract. Without contract override provisions, please read the part carefully. Contract override refers to contract override related to exemptions under the bill. You talk about sexual discrimination. I don't see how it is related.
Well, Chairman, perhaps you might have misunderstood what I meant. I said if we were to follow the terms of use of Facebook, we need to first of all interpret the terminology, but that means we need to check the definitions in our local legislation. But what's the relevance with the exceptions in the Copyright Amendment Bill? Well, Chairman, because this is the second time, Mr. Chairman, this is the second time you speak, and I'd like to remind you not to depart from the objective of the debate, that is whether there should be any restriction on the contract override in relation to copyright exceptions. Well, Chairman, I was referring to a number of terms in the Facebook terms of use: bullying, threatening, harassment. But what's the relevance with the Copyright Amendment Bill? If we are to interpret what these terms mean, we need to turn to the interpretation of local legislation. Well, Mr. Cheung, I'm sorry. Please do your preparation before you speak. Well, of course, there are different restrictions as far as contracts are concerned, but we're talking about override provisions in respect of copyright exceptions. I've reminded you a number of times, so I am afraid I cannot allow members to engage in a debate unrelated to this debate. Well, anyway, Chairman, I have made my point, and in fact, Facebook has on more than one occasion invoked the relevant terms to cancel or deactivate the user's account. For example, in relation to June 4th incident, local social activists such as Mr. Leung Kwok Hong and also local photographer Ben Zheng's accounts were, for no reason, cancelled. With the help of Mr. Charles Mock and with much effort made, these accounts were reactivated. However, the effort to cancel or to deactivate Facebook accounts has been going on. Well, I have to stop you, Mr. Zhang. Well, even if Mr. Chan Kam-lam's amendments are passed, there is no effect on what you said just now, because what you said, in fact, doesn't relate to contract override provisions in respect of copyright exceptions. Please don't digress. All right, Chairman, but if we are to extend the application of the copyright bill, we need to look at the situation. For example, for Facebook, there is a reporting mechanism. That is to say, if we don't handle contract override properly, when users are allowed to report each other, then pro-establishment Kam and the pan-democratic Kam may report each other, and this may create chaos in society. Well, Mr. Cheung, I don't think there is chaos in society, but rather in your logic. I still don't see how your speech is related to the contract override provisions in respect of copyright exceptions. Thank you for your enlightenment, Chairman. But we can see how terms of use in the business context may apply to a political situation. For example, the CEO of Facebook, Mr. Zuckerberg, said on many occasions that the Facebook's terms of use can be adjusted in
in order to tap the mainland market, because the CEO of Facebook understands that he can reap more benefit if he reap a bigger profit if he could cooperate with the political requirements in the mainland. So you can see that this is not an impossible trend to tighten the freedom of speech online because of political reasons. Under the existing system, copyright owners can make a profit. So that is to say, online platforms will not indiscriminately restrict internet users' right to publish secondary creations or make comments because of market operations. Because, like I said, the companies may also consider their political reasons. Although there may not be criminal offenses in relation to the communication rights, in the future, the companies may still sue netizens in the future. They reserve the right to do so. In the future, if there is a change in the political situation, if companies can make more profit, they can invoke this right to sue netizens. And also, when user accounts are being revoked, internet users do not have the same bargaining power. So ultimately, the decision lies with companies. User history and the friends list will also be destroyed as the account is cancelled, and there may be more conflicts. For example, for Weibo, the terms of use are consistent with the political situation in the mainland. Weibo is the popular social media platform used by users in Hong Kong and the mainland. And netizens in Hong Kong's concern is reasonable. If we have restrictions on contract override provisions, this can its application can be extended to platforms such as Weibo. Now, for example, if somebody incites online urging people to go for a bank run, then this will constitute a criminal offense using computer with dishonest intent, and this should also apply to the internet. So the exception should also apply to the internet, but then the contract override provisions, restriction provisions should also be allowed so as to increase protection for users and enhance their bargaining power with companies. Well, the government says that this amendment bill is already a big step in terms of improvement. However, if there is no restriction on contract override, then the new exceptions will become non-existent. And this copyright amendment bill cannot be regarded as an improvement, and therefore Mr. Dennis Kwok's proposed restriction on contract override seeks to provide legal backing so that the exceptions can also be applicable in the private contracts, so that the spirit of the Copyright Amendment Bill can be realized, that is to protect the freedom of speech, and the government and the pro-establishment Kam members should support this amendment. I so submit, Chairman. Now, for members who have spoken in this debate, they have spoken for 43 times, with 14 members having spoken for more than once. Now, I have begun to notice repetitions and digressions. So, for members who wish to speak, I want to remind them that you should not digress, you should not repeat yourself or repeat the points that have been made by others. If I continue to notice the same situation of digression and repetition, I have no alternative but to draw the conclusion that there is no input to this debate, and then I will end this debate. Mr. Charles Mock, speaking for the third time.
Talking about can be relevant to our debate if you consider the fact that if a particular social media platform or online service company can introduce a particular conditions to ban certain expression on its platform in certain ways, as as the Honourable Zhang talked about in sexual discrimination or whatever, they could easily also in future potentially also add similar contract override terms that has to do with copyright. So the fact that they are not there today in the contract doesn't mean that the threat isn't going to be isn't going to be a situation that can happen in the future.
Well, this argument doesn't hold water. Even if what Mr. Charles Mock said is sound, I still think that Mr. Peter Cheung has digressed.
So I just want to respond very quickly to that particular point only. In my previous presentation, I was talking about the prevalence of the contract override terms in many other countries, to the extent that, for example, according to a lot of surveys in Australia, their national libraries and so on, basically there were a lot of these contract overriding terms in the materials they were trying to loan out to their citizens and so on, that actually in reality citizens cannot make digital copies or even cannot make digital duplicates. So in reality, what they found is that none of the contract terms that allow personal use of these materials in the libraries that are actually explicitly some of the exemption provided to users in their jurisdiction were actually enforceable. And in other words, all the contract override terms actually were able to override the legal exemptions that were already provided in law. And universities and academics in Australia also pointed out that the widespread contract override usage in teaching and instruction, exchange between libraries and loaning out of books, and allowing users to transfer the content over the electronic media, all of these were actually originally allowed under fair dealing in their law. In fact, these limitations on contract override apply, but on the other hand, actually, contract override terms isn't something new, even for copyright laws. In fact, they are often applied to computer programs, and this is very prevalent in this is present in the laws in many copyright laws in many countries, including New Zealand, Singapore, the EU, and so on. Now, even in Australia, there is an limitation on contract override in some computer programs related situation under their Section 47H of their Australian Copyright Act, ACA, which prohibits contract override against the reproduction of computer programs for storage, cache, technical research, security inspection, or error debugging. In fact, back in 1995, the Australian Law Reform Commission they made a comment that such contract override terms had rendered the related exemptions under law useless. So in 1999, the Copyright Amendment Computer Programs Act in Australia was introduced, and they used the European guidelines as its reference. Now, Mr. President, I want to come back to the situation in the UK, because we often look at UK as the first jurisdiction that implemented a more general contract override limitations on contract override, the more general limitations on contract override. Now, how did it happen in the first place? We should look back at the Hargraves report in 2011, which was entitled Digital Opportunity, an Independent Review of Intellectual Property and Growth. Now, before I continue, actually, I would say that my understanding is Professor Ian Hargraves actually will be in Hong Kong in mid-March. Okay.
郑志全議員。
Mr. Chen Chi-chen, I ask for a quorum call.
請議員返回座位。
Would members return to your seats, please? We need to count the number of members.
傳召議員嘅時間已經過咗15分鐘，會議廳內不足法定人數，本會現在回復為立法會。我現在宣布休會。